Is it legal to modify your concealed carry firearm?
Modifying concealed carry firearm, there's nothing wrong with it from a legal standpoint. What you need to be aware of is the fact that if that weapon is used in a self-defense shooting, it's going to be taken by law enforcement and be evidence in a case against you if you're prosecuted. And what you don't want is a modification that either causes a jury to think that you had anything other than lawful intentions when using that weapon, or if there's a civil litigation, things that would indicate that you might have racist or other type of ulterior motives in using self-defense. My advice, if you have a weapon and you're going to carry it daily for self-defense, have it be straight out of the box. You can change the sights, you can change those types of things, but modifying the trigger pull, modifying the slide, modifying things that change the function of the weapon can cause problems not only in the civil arena but as well as the criminal arena as well, if in fact you're prosecuted for using it in a self-defense shooting. If your gun or your firearm is used in a self-defense shooting, your gun will be taken by law enforcement. It's evidence. There's no getting around it. How long it is held, it could be hours, days, weeks, it could be years, depending on how far the litigation or the prosecution goes in your particular case. You need to be aware that your gun will be taken. You need to be aware that law enforcement, when they arrive at your home, if it's still an active scene, may be yelling at you with their guns drawn to drop your weapon, to get down on your knees, and that you need to comply with those requests, because when law enforcement arrives, they don't know who the good guy is and who the bad guy is. So you need to comply with their request and know that they are going to take your weapon, at least the weapon that was used in the shooting, until such time as it's no longer needed as evidence.
How can you prove that you felt that you were reasonably in imminent danger?
Proving you were in imminent danger to the point that you're justified in using self-defense, it seems like it would be simple to do, but that is really the crux of an entire self-defense litigation. What you have to do is convince the powers that be, convince the judge, the jury, the prosecutor, that in fact you were justified in using deadly force. Sometimes that comes from the evidence, sometimes that comes from eyewitness statements, video. Sometimes the crime scene itself lends itself to proving that, and sometimes it's just your word against the person who was shot, and if they don't survive, sometimes it's just your word against the police investigation. There is no easy way to prove it. That is really why having a lawyer involved in the case from the start, a lawyer that knows the ins and the outs of a self-defense shooting case, is so important to help make sure that the evidence is coming to the fore, that the police are focusing on the right suspects, and that the prosecutor sees it your way so that you aren't in fact taken into custody or prosecuted for something that you're not guilty of.